All right. No, I mean, it appears that it isn't because you're getting angry throwing somebody's keys.
No, but it's a reason though, because she was drunk though, so you know what I'm saying.
Oh,
I
okay,
could have just let her leave.
all right, let's be clear. You were not doing this to stop her from, who's here on Crystal Molina?
Good morning, Judge.
Good morning. So where we're on this?
We
case?
have money today. We have
Oh, wow.
$5,000 in a
How
cashier's
much?
check, 5,000.
Okay, awesome.
Mhm.
Then let's proceed.
Okay.
Ms. Abrams, on this sentencing, they have $5,000 for the complaint, and if you can instruct them where they need to deposit that. All right, we're here for sentencing, correct?
Correct.
All right, the court is calling 2024 CR 4065 State versus Crystal Molina. Can I have parties announced for the record for the state?
Nicole Thornburg for the state.
Monica Anna Guerrero for defendant.
And are you Ms. Molina?
Yes.
All right, you entered a plea to count 2 on December 19th. According to the plea bargaining agreement, punishment was to be assessed at 2 years in the state jail facility. There's a $2,000 fine. There's no application for deferred adjudication. There's to be restitution of $10,000 to DZ Industries, and you were to agree not to be employed in a capacity where you are in control or handle any type of funds that are not your own. Are parties ready to proceed with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Not right now, Your Honor.
All right, so my understanding, since you have the $5,000 cashier's check, and is that made out to DC Industries?
It's made out to Bayer County CSCD.
All right, so Ms. Abrams, if you can make sure that that goes directly to restitution. All right, then, so the remaining restitution amount will be $5,000, is that correct?
Yes, sure.
Yes.
And Ms. Abrams, on this case, if you could make sure they set up a payment schedule for her, and if she missed any payments towards restitution, let the court know so we can have a compliance hearing. So do you have any children?
I do. I have one son. He's 23 years old and a grandson.
All right, and how old is your grandson?
A year and a half.
And what do you do for employment?
Well, I was doing accounting,
Okay,
sales, customer service.
so, I mean, are you currently employed?
I am not. I'm looking.
All right, so in this court, I require that everyone have employment. If they don't have employment, there needs to be a reason. For example, if they're on SSI, then they need to provide proof of that. Do you understand?
Yes, ma'am.
All right, the court is going to sentence you to the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. If you're able to pay off everything early, then the court will reconsider.
I just want to clarify that it's 4 years that we agreed on.
No, that's outside your agreement.
Okay.
It's just what is recommended by the state. If you complete everything early, then you can perhaps be terminated early. Do you understand?
Yes, ma'am.
But the key about this probation, you need to pay that $5,000. Do you understand?
Yes, ma'am.
All right. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors or in any occupation where you are in control of any type of funds. So you can't be a cashier, you can't do any of that. Do you understand?
Yes, ma'am.
To clarify for my client, employment with minors or elderly, is that what it was?
Home healthcare
Healthcare.
provider. So
Okay.
she can't be in any position where you're working with vulnerable people. So for example, the home healthcare field, you're not to be help someone at their home. You're not to take care of the elderly. You're not to take care of minors. Do you understand?
Yes, ma'am.
So if you want to work at a fast food restaurant, you can work at a fast food restaurant. If you want to, well, you're really limited since you're not able to handle money. You're not able to be a cashier.
Right.
So if you want to work at a restaurant, you can work at a restaurant. They can give you your tips, that's fine. But anything where you are involved with exchanging money, you're not allowed to do.
Okay.
All right, if you want to be a hostess at a restaurant, you can be a hostess. All right,
Yes, ma'am.
or if you want to be a welder. So no involvement, no occupation involving the transfer of funds. And I'll give you 45 days to
45 days.
find employment.
Yes, ma'am.
There's to be 200 hours of community service restitution. You okay? 100 hours will be waived if you decide to obtain a higher level education, or if you decide to obtain a certificate or welding or anything of that nature. You understand? And if there's something else that you would like to do to improve yourself, then just let probation know, and I'll consider deducting the community service hours for that. You understand?
Yes, ma'am.
There's going to be field visits 1 time per month for 6 months. There's to be restitution of $5,000 to DZ Industries. And that restitution amount, Ms. Abrams, is just what she will owe remaining on the $10,000.
$10,000.
Yes. And I'll notate in the docket sheet that you paid $5,000. There's a $2,000 fine that will be probated. And can you tell the court, why did you take these fines?
I don't want to give you an excuse. It was just a bad choice on my part. I mean, I can give you the excuse.
No,
but
no, give me the,
Moving, well, I was a single parent. I know it's not an excuse because I could have got a second job.
yes.
But it was just a bad decision. And moving forward, I would like to do what is necessary by you and the courts and probation and move forward.
All right, and the reason why I asked that question, I asked that question so that I'll know if there are any other courses that are needed from you, okay?
Mhm.
So, Ms. Abrams, and I'll deduct another 100 hours from the community service, but I am going to require you to complete the MRT course. All right, is there anything else, Ms. Abrams? Is there anything you need from the court to be successful?
No,
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
yes, ma'am.
And did you sign it?
I did.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, in this court, to be successful, communication is key. If you're having an issue, let your probation officer know about it. If you feel as though they're not addressing it, then you can always come back to the court and we'll figure out what's going on.
Okay.
All right, good luck to you.
Thank you
And
for your
thank you. You
time.
always dress appropriately for court. I appreciate that.
Thank you.
Have a good one. Yes,
On that one.
count 2. You're welcome.
Thank
Thank you. Thank you. Remember, what page is Molina on? All right, thank you. All right, court is calling 2025 CR 0000286, State versus Joshua Dwayne Pollard. Could I have parties announced for the record for the state defense?
Kelly Biddle.
And are you Mr. Pollard?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Are there any applications?
No.
Mr. Pollard, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes,
State, are you proceeding on the indictment as presented? All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with unauthorized use of a vehicle as a repeater. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? Here, our counsel.
oh, thank you, Judge.
Any witnesses? Thank you. The state would call.
Ma'am.
Did you understand you or your attorney would have the right to cross-examine any witnesses the state would call?
Yes, ma'am.
And you would have the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court does not have to follow your plea? If for any reason the court gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes,
Mr. Pollard, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
All right, off the record for a moment. So part of your plea bargaining agreement, you to plead true to enhancements for purposes, I'm sorry, as part of your plea bargaining agreement, you're to enter a plea of true to any of one or more felonies for purposes of enhancement. Punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. There are no applications. The state is taking in consideration 2024 PF 20093. And there's to be restitution of $1,700 to Liam O'Neill. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes.
State is at the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by citing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
And to the enhancement paragraph, how do you plead? True or not true?
True.
State any evidence.
Yes, Your Honor. Exhibit number 1 with all its attachments. No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and cite it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial?
Yes,
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No.
All right. Then the court will follow your agreement. The court will sentence you to 3 years in the prison, give you credit for any time served, taking consideration 2024 PF 20093. There's a $2,000 fine. There's to be restitution of $1,700 to Liam O'Neill, and there's to be no contact with Christopher Adams. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
41 ma'am.
All right, you're gonna have to start making changes. Otherwise, you're gonna look up, majority of your life is gonna be in somebody's jail or prison. You understand?
I understand. ma'am.
All right, good luck to you, okay?
Thank you.
You're
Thank
welcome.
you, Judge.
Norma, which page is Pollard on? Thank you. Celeste, Alexandra, Juarez.
Herrera on that motion for continuance from Monday?
Yes.
Okay, thank you.
Thank you. As soon as he gets out, we'll be ready.
Okay. Hello.
Morning, Judge.
Good morning. All right, so I'm in receipt of a motion for discovery and inspection. Did you review this with defense?
Judge, I have,
All right, any objections to any of the requests?
just a couple, Judge, under section 1, I'm sorry. this is going.
That's okay.
Under the first request, statement asked that exclude any work product. Whenever I meet with a victim, I do a summary of anything that may be.
Our intent is not to ask for work product. My
So
concern though,
regards-
my concern in general and not with Ms. Brown, because she is definitely thorough. And then as you'll see, I think she's gonna put in another disclosure. I think if there's a statement that that's not work product. And so her notes may be work product, but the statement is not. And so I just want to make sure that if there is a statement that we're aware of it, and then definitely if there's nuanced differences or differences between that statement and what we received, that we receive that.
Well, with regards to your notes, are there a synopsis of the meeting? Or are you taking word for word?
Oh, no, they're synopsis. They're literally just like quick jot down. Somebody will say something and I'll jot down 2 words. And then I'll go type something that I'm thorough using thoughts and put full sentences together.
All right, the court then is excluding the work product. Counsel, if you feel if there's something, I can do an in-camera inspection.
Thank you, Judge.
All right, we're gonna go on the record in 2023 CR 2023 CR 8101, State versus Celeste Juarez. Can I have parties announced for the record for the state
State,
defense?
Jason Todd for defense.
And are you Ms. Juarez? All right, so off the record, with regards to number 5, motion for discovery and inspection filed by the defense. With regards to number 1, the court is granting that based upon the agreement of parties. It will exclude state's work product, but if necessary, the court will perform an in-camera inspection. All right, with regards to number 2,
Judge, there is none to my knowledge, but if I discover that there is, I will disclose it.
all right, that'll be granted. With regards to number 3,
State has already provided a witness list to defense. The only thing is we don't have personal addresses for the victims due to safety issues. We have for the officers and the school professionals, we have the school addresses, the work addresses, or work information. To the best of my ability, and if I find more information, I'll provide it.
all right, so the court, based upon the state's representation, do you have any objection to not including the addresses of the complainant?
Well, Judge, I understand not filing it in a public record. I also, though, I don't understand the safety issue of disclosing it to defense.
All right, so what do you want to do with the
If she-
address? You want to go out to the address of the complainant? Is that in some way related to the alleged offense?
If there were reports we wanted to know if there's been calls to the house, if we wanted to do research on the complainant, we would not. That being said, we have the address of the complainant, so that's not the issue.
All right, so you
So
already have.
I have that address, but safety concerns for if there's more than the complainant. We need the ability to research these witnesses, and we need the ability to know what's going on regarding their
Well, my
testimony.
understanding is the only thing the state is not wanting to turn over is the addresses. Is that correct?
So it's the addresses of the complainants, and I'd have to look around, I'm sorry, I don't have my witness list. It's the address of the complainant and complainant's mother, guardian.
Well, he says he already has the address of the complainant and the complainant's mother, so that will be excluded. You already have it.
And
Yes,
the
Judge.
personal addresses of the professional witnesses, but they are identified by the word place to the best of their ability. And
All
if additional information comes, I will turn it over. I'm giving you the ready.
right, with regards to professional witnesses, I'm assuming the professional address for their business. You don't need their home address, do you?
We do not, just the ability to contact them and reach out to them if that need should arise.
All right, I'm going to notate that defense has in its possession the address of the complainant's address, so that's not needed. So what I'm going to order is that there is to be state, you're to turn over all the names and business addresses of individual witnesses. And if for some reason there is an address that you feel that you need, that is a person's personal address, just come back and we'll have a hearing.
Thank you,
But
Judge.
that'll need to be done, not at the last minute.
Understood, Judge.
Okay. Number 4,
To my knowledge, Your Honor, there is no informant in this case. If one becomes known to the state, we will disclose it.
all right, thank you. And let me ask you all this, is CPS involved in this or no?
Yes, Judge.
All right, so sometimes the confidential informant could be the person who reported it.
So CPS comes in after the initial report to law enforcement. I think, was it law enforcement or without the CPS, I think?
I would have to look at the timeline. CPS is, we know who told CPS. I will say that. I don't think that's an issue in this case, Your Honor.
All right. Because if it is, then my ruling on this, granting it, I'm going to rescind that because that's supposed to be confidential.
I understand, Your
All
Honor.
right.
I don't think that's an issue, though.
All right. And number 5,
That's to number 5, Your Honor. The only issue state has is.
everyone, please whisper. And everyone, we're on the record, so no talking behind the court reporter while we're on the record. All right, number 5.
The only issue is the rank and badge number of the police officers. Some of them have changed agencies, some of them have retired. I don't have all of their badge numbers or rank. As to what information is current and that I can provide, I will provide it, but I don't have all their historical information for what their rank was. And I also don't know if he wants rank at the time of the offense, badge number at the time of the offense, future badge numbers. It's a little vague for me.
I guess my response would be to that if she gets updated information and she's talking to her witnesses, if we get to the place where we're prepping for trial, we need the ability to know where her witnesses are. If she's, I have no doubt she's given us what she has, but if she finds out something new, I think we do
Okay.
need to know that.
So as far as where her witnesses are, that would be taken care of with regards to defenses number 3. So
I-
do you really need to know the rank and badge numbers?
Yet the rank is helpful, but the badge number is important because if this law enforcement officer has moved to a different agency or within the agency, if we want to look them up and look up what they have, perhaps discipline or get information from the agency, I have found the easiest way is a badge number.
All right, so you don't need their rank.
I guess I don't need it.
All right,
It does.
so then if you have the rank, then give them the rank. But if you don't have the rank, then she doesn't have the rank. And it is vague based upon what she's stating. Do you want their rank at the time they were involved in this, or do you want their rank now? So if you have their rank, give it to them. If you don't have the rank, and if there's an issue, then just come back to the court. If you have their badge number, give it to them. If you don't have their badge number, then come back to court.
Thank you, Judge.
And I'll write that the defense is to approach well before trial if there's an issue with the rank and badge numbers.
And if you, Judge, I have my phone out, but I'm just taking a note.
Sure, oh, no problem.
Thank you, Judge. Thank you. Thank you, Judge,
You're
for
welcome.
that indulgence.
All right, and then number 6.
There is no issue with that request, Your Honor.
All right, is there anything else?
As to the motion and the specific order attached, Your Honor, I would just ask that if the defense needs to physically pick up any tangible items that are not able to be transferred via e-discovery, that they come pick them up here. They're in the building every day, and I don't have a work vehicle to take them to the office.
And we're fine with that, Your Honor.
All right, so I'll put on here. All right, so State, have you gone through each order that they're saying they want 48 hours, within 48 hours of the time it learns or obtains discoverable matter?
Yeah, Judge, if it's within 20 days prior to trial, yes, we're gearing up for trial, that's fine, Judge. I'm pretty.
All right, so you've read through the order and you have no objection to the court signing the order as is, but the court will add the line that if there's anything that needs to be physically transported, the defense needs to come and pick it up from you?
That and just with the provisions regarding the product, if that's somehow incorporated into the order, that will probably not be turned over without waiting for it.
All right, so if you all will write the additions to the order, the court will sign it. And then all of the other discovery has been tendered.
I'm sorry, what was that?
All of the other discovery has been tendered because the last time we were here, it was the complainant school records, CPS, any additional records, the IDR, dispatch received, calls for service, statement made by the school nurse.
So regards to those items, Your Honor, we had turned over CPS, defense believes there's items missing. We're gonna send a more specific to Davina to specify those items and see if they're turned over. There was some body cam that defense believe existed. We asked about it. I just found out this morning that that body cam does not exist any longer. It did once, and no longer does. We're getting an affidavit of no record, and I've provided a written disclosure to defense regarding the restitution. As far as the IDR, CAD, all of that, there's one thing that relates to those items, and we have turned that over to defense. The nurse's statement was turned over. We clarified with the nurse or with the detective that the only statement made by the nurse was the nurse's reports. And so we've gone through each of those items. The only outstanding issue is the affidavit of no records for those body cam videos and the requesting the CPS to see if there is additional material that can be displayed, can be turned over. We did request all CPS records prior, but sometimes if you don't specify videos, documents, etc., sometimes they don't want to.
All right. Defense?
That is an accurate depiction of where we're at, Your Honor.
All right, so this is what's going to happen, and this will be your last setting for discovery. And if there are items that are missing, or you see that when we have this next hearing, that there are going to be items that are missing, you need to subpoena witnesses to have them here. They can appear by Zoom if need be, but this will be your final discovery. And also on this date, if you have not, you'll need to tender an offer to the defense.
We are in negotiations with the federal government. I don't think we have a firm one at this point, but we've been talking.
All right, so, Ms. Ferguson, recall this for, March 27th.
I'm sorry, Judge.
Yes.
I'm unavailable on that date.
Okay. Oh, I'm so sorry to hear that. What is a good date for you? I was just trying to give you a longer setting.
I'll be back the following week. the first-
Norma, put this then on April 1st. And if you all don't have the remaining of the discovery, then witnesses will need to be subpoenaed to be here on that date,
I'm so sorry, Judge. What was that date?
April 1st. You're welcome. And defense, if your client wishes to appear by Zoom, your client can appear by Zoom.
Thank you, Judge. We appreciate that.
And what page is she on, Ms. Ferguson? All right, if you can have a seat. Thank you so much for dressing appropriately for court as always. Just have a seat and the coordinator will bring you your reset form. And once you sign the reset form, you're excused.
Thank you. Have a great day.
All right, thank you. You too. Who is the attorney for Dustin Murphy? All right, Bradley Galvon.
Sorry, Judge.
That's okay.
Restitution. He's in custody. Yeah, he's in custody of the county.
I was like, you gotta verify.
Yeah, yeah, he's in custody of the county.
All right, counsel, you're on this side.
Thank you, Your Honor.
Why were you late for court?
I haven't been downtown or to court. in a
I'm sorry,
while.
what?
I haven't been here in a while, so.
All right, so don't be late again. You
Yes,
now
ma'am.
know where it is. You understand? All right, where are we on this case?
Judge, I have asked the prosecutors to take a look at the body worn camera. I think it was the version I have, I think is too short.
Okay.
Also, I asked them to look for Coban, even though the Senate Bill 111 indicates there is no Coban. It's kind of strange. It's a lieutenant doing patrol, which is kind of strange.
Mhm.
Also, there are some pre-filed cases that have yet to have labs come back on them.
All right, these pre-trial cases, what are they?
There are 2 drug cases, Judge,
And what is the alleged amount?
4 to 200.
All right. All right, Ms. Ferguson, recall this for discovery on March 31st and state.
Yes.
Do you anticipate having the labs back on the other cases? All right, so let them know that I want to be surprised if you can call them and tell them the labs are needed for that. All right, thank you. Is there anything else?
No, Your Honor. Thank you.
Right. You can have a seat once you sign the reset form. You will be excused. And I can't believe you're in here with a Texas A&M top and you're in front of an LSU's Tiger.
I'm sorry
I don't
about
know.
that.
I don't know. I don't know.
I have a piece of paper to you.
That's okay. We're cousins.
He may have stepped away.
All right. All right, court is calling 2022 CR 5005 State versus Pedro Rodriguez. All right, if y'all could approach. Never have parties announced for the record, for the state,
Rick Bader for the state of Texas.
for the defense.
David A. Garcia, attorney for Pedro Rodriguez.
Are you Mr. Rodriguez? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Pedro Rodriguez who was placed on deferred adjudication in 2022 CR 5005 for the offense of assault, bodily injury, family, household on January 9, 2023 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
The state will be proceeding on its motion for adjudication of guilt and location of supervision. Violation condition number 15 on or about the 29th day of July 2024 in Bear County, Texas. The defendant, Pedro Rodriguez, did then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program, anger management program, violation of condition number 15.
How do you plead to that? True or not true?
State will waive all other violations. Your Honor.
Any
no
objection?
No objection.
You understand by pleading true to violation of condition 15, the court can find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to violation of condition number 15? Is there proposed, the court will find violation of condition 15 true? Is that proposed agreement?
Yes, Your Honor, it's to revoke the defendant's probation on the case at 60 days in the Bear County Jail. Give him credit for time served.
That is the agreement, Your Honor.
All right. Has he done anything on probation?
He did quite a bit, I believe. He did pay some, he reported,
He took a lot of urinalysis tests. Most of them were negative.
So why didn't you successfully complete this probation? You can raise your right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Pedro Rodriguez.
All right, why didn't you successfully complete probation? You're whispering.
Ran into problems.
Oh, what problems were those?
Well, Judge, he's currently been indicted on another charge out of this court. We wanted to kill this and move forward on that case.
All right, the court is finding you guilty. The court will grant the motion. There's an affirmative finding of family violence. The court will sentence you to 365 days in the Bexar County Jail, give you credit for any time served. There's to be a $4,000 fine. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, the other case he has pending out of this court, has that been indicted?
It was indicted just in January, in December, late December.
All right, could somebody give me that file?
And Judge, regarding this, I believe state was recommending judgment sat.
No, I'm not doing a judgment satisfied. And I'm gonna give you a date for your new case.
And Judge, regarding the new case, we would just ask that the state look into the discovery of CPS records.
Okay. We are gonna do that, and I'm gonna give him a date. That way you won't have to come back. And let me see what page he is on. All right, thank you. All right, so with regards to this case, and we're off the record. This is for the 2024 CR 012355. We were here in January for CPS records. What's the stance on the CPS records? Do you have them in your custody? Or I should say in your possession? All right, other than the CPS records, counsel, is there anything else?
Other than that, Judge, I think the CPS is the records will allow us to look to see about any other allegations that were made against any other innocent people that were charged.
All right, we're gonna call this back on March 31st.
Judge, I'm not going to be here that day.
When will you be here?
Anytime in April, Judge.
All right, we'll recall this for April 1st for discovery, Ms. Ferguson. State, you need to be prepared to tender an offer. All right, is there anything else?
No, Your Honor.
All right, thank you.
That's in March.
April 1st.
Have a good day, Judge.
Thank you, you too.
My client said when I text him or anybody calls, it kicks him off. I may have.
Okay,
Told me.
I'll see if he's back on. Jose Cervantes,
Morning, Judge.
good morning.
We need the court interpreter.
Oh, the interpreter's here.
Yes.
We'll have to go to the admin and get a proper one. All right, so on this case, counsel, I know we didn't have our setting last time because you were in a jury trial.
That's correct, Judge. I was in a jury trial. And so essentially, this is my first appearance here. Mr. Cervantes. We have received an offer from the state. And additionally, there's a bunch of discovery that I need to go through, including some child safe videos, I would imagine, more than one. So that's the reason we'll be asking for a reset today.
All right, and is there any CPS records in this case? All right, and then is your client a citizen?
Are you a citizen of the United States? It's a resident.
I'm a resident.
A resident.
All right, so do you need MAC for immigration purposes?
Probably do, Judge, yes.
Although with this charge, it's deportation, but okay. Ms. Ferguson, if you can make sure that MAC is on this case?
Yes, ma'am.
Thank you. All right, then we'll recall this. What date, Ms. Ferguson? 30 days?
April 3rd.
That'll work.
Is April 3rd a Wednesday?
Thursday.
Thursday? Okay. All right, we'll come back on April 3rd.
Do you have the link?
No, not at all.
All right, does he have any questions?
Gracias. No.
No.
All right, thank you.
And Judge, before he goes back real quick,
Toma asiento.
we're gonna do a jail video call. We'll have more privacy to talk about.
Ricardo Garcia.
Cuando
Siéntate.
All right, they're not ready on that one. Abel Favala, are you all ready?
Also known as.
Sure.
Reference to Mr. Favela, Judge.
Yes.
He just got out of lifetime recovery last week, and I had been dealing with Megan Galloway on this one. We were gonna speak as to what she was intending to offer in terms of the medical records to see about what kind of amount. But it's my understanding that she's ill.
Yes.
So we just wanted to get a brief reset so I can follow up with her in advance and make sure there's no issues as to what she intends to introduce for this restitution.
All right, we can recall it for, do you want to recall it for March? Oh, is that Mr. Favala?
Yes, I guess he was under the understanding, I think, that his case was called, but this is
All
Mr.
right.
Spencer. Sometime in March, whatever works best for the court.
So we can do it for March 3rd. Do you think Ms. Galloway will be back then? All right, we'll do March 6th.
March sixth.
Ms. Ferguson, if you can recall him for March 6th, it is Abel Favala. All right, thank you.
Thank you.
Once you sign the reset form, you're excused.
Yes.
And thank you for dressing appropriately for court.
Thank you. Have a good day.
Oh, thank you, you too. And Norma, what page is Favala on?
On page 9.
Thank you.
That's us.
Javier Herrera.
Morning, Judge.
Good
This
morning.
is, as you will recall, the gentleman we spoke to, I don't know what day it is anymore, Monday, I think, when we were here for the trial docket in the state. Mentioned their witness was pregnant and a flu, and
Yes.
I think they filed, I know that they filed a motion. I received a copy of it, so we're back on that.
All right, court is calling 2021 CR 2011 State versus Javier Herrera. Could I have parties announced for the record for the state?
Ashley Jones.
Defense?
Charles Bunk.
And are you Mr. Herrera? All right, this case was scheduled for jury trial, but the state Hello.
Okay. All right. Thanks for that.
Morning, Judge.
Hello. Hi. I like your shirt.
Thank you.
All right. Where are we on discovery?
Yes.
These are three nightmare cases, Judge.
Oh. So
You
you're
have
here
the
asking
motions?
for the bond conditions to be modified?
That's correct. We did it once on January the 16th, changed it from no contact to supervised contact. And now you'll notice on page 2 in the center of it, I've got a response request from the CPS worker. They'd like to move forward with family reunification. The civil court has not issued a written order.
Just 1 second. Let me.
I'm sorry,
read
that's
this. Just a second.
that was filed back on the 13th. Each one is identical.
All right. So I need the order from the civil court. When did
There
they
is no
have-
order, Judge. The court is not, as of yesterday, they have not signed an order.
All right. So who is the children's attorney?
The ad litem is a
Ms. Bell.
Kathy Stout. I have emailed and called her and had no responses on the 7th of February.
All right.
I do have the CPS worker as well, and I quoted her on the second
Alright.
page, but
Does anybody have Kathy Stout's?
I've
cell
got her.
number?
I've got her phone number.
All right. So if you'll give that number to Ms. Ferguson, or if you can call Kathy Stout and see if she
She
can.
probably won't answer me. That's why.
Oh,
That's
better
why I said
now. I
she
think she
hasn't
would.
answered.
You know what? Once you put it in the universe, then it's not gonna happen. See if
I'll get it.
she's available to zoom in.
All right.
All right, just have a seat.
Thank you, Judge.
All right, who's here on Channing McFarland? Court is calling 2025 CR 0000513, State versus Channing McFarland. Can I have parties announced for the record for the state?
Jason, your hand, Your Honor.
Defense?
Good morning, Judge. Dirk Ashball for Mr. McFarland. We're ready.
And are you Mr. McFarland?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Are there any applications?
No.
Mr. McFarland, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Sure.
Mr. McFarland, did you review the document entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility
Yes,
and up
ma'am.
to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. McFarland, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 100 days in the Bear County Jail under 1244, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any
30 days, Your Honor.
Is what's happening with him going to take 30 days?
Possibly, unclear.